Hello everyone, welcome to the channel Scientellectual. In the current video, we will be covering few more sections under Chapter 18 of Indian Patents Act 1970. Chapter 18 deals with suits concerning infringement of patents, and sections we are covering in this video are section 107 to 111. Section 107 Defenses, etc. in suits for infringement. In any suit for infringement of a patent, every ground on which it may be revoked under Section 64 shall be available as ground for defense. That is, every ground under Section 64 for revocation of a patent is applicable as ground for defense as well. In any suit for infringement of a patent, by making, using, or importation of machine, apparatus, or other article, or by using any process, or by importation, use, or distribution of any medicine or drug. So in these cases, suit for infringement of a patent can be done. It shall be ground for defense that such making, using, importation, or distribution is in accordance with the conditions specified under Section 47. Section 107A. Certain acts not to be considered as infringement. Subsection 1. For the purpose of this Act, A. Any act of making, constructing, using, selling, or importing a patented invention for the use of reasonably related to the development and submission of information required under any law for the time being in force in India or other country than India that regulates the manufacture, construction, use, sale, or import of any product. And B. Importation of patented product by any person from a person who is duly authorized under the law to produce, sell, or distribute the product shall not be considered as an infringement of patent rights. So, if making, constructing, using, selling, or importing of patented invention is used reasonably, that is, there is very much reason which is related to the development, and submission of information is done under the law, then importation or making, constructing, using, selling, or importing is not to be considered as infringement of patent rights. Section 107A under Indian Patents Act is a very important chapter. This is also known as India's Bowler Exemption. It is named after landmark US case Roche Products versus Bowler Pharmaceuticals. Bowler exemption is the exemption that enables generic manufacturers to experiment with patented drugs and produce them in limited quantities for research to use an inventor's pharmaceutical drug before the patent expires. Now in section 107A, it is recited that development and submission of information required under law for the time being in force in India. The clinical trials and marketing approvals or marketing authorization application would come under information required under Indian drug regulations. A relevant case law can be referred here, that is Bayer Corporation versus Union of India and others, and Bayer Intellectual Property GmbH versus ANR versus Alembic Pharmaceutical Limited. Here it was held that exporting for research and clinical trials comes under the scope of Section 107A as bowler exemption, and there will be no impairment of patentee's rights. Section 108. Reliefs in suit for infringement. Subsection 1. The reliefs which a court may grant in any infringement suit include an injunction and, at the option of the plaintiff, either damage or an account of profit. So, relief can be injunction, and at the opinion of the plaintiff, it will be either for damage or account for profit. Subsection 2. The court may also order that goods which are found to be infringing, materials and implements, and the predominant use of which is in the creation of infringing goods, those will be seized, forfeited, or destroyed, and without giving any payment for compensation. Section 109. Right of exclusive licensee to take proceedings against infringement. Subsection 1. The holder of an exclusive license, that is exclusive licensee, shall have the like right as the patentee to institute a suit in respect of infringement. That is, whatever right in case of infringement suit a patentee has, same kind of right an exclusive licensee will also have after the date of the license, obviously. And in awarding damage or account of profit or granting any relief, court shall take into consideration any loss suffered by the exclusive licensee or the profit earned by means of infringement if there is any infringement. So, whatever loss an exclusive licensee, if any infringement case has occurred, the exclusive licensee suffers from any loss, then court will take into consideration of that loss before taking any decision regarding awarding damage or account of profit or granting any relief. Subsection 2. In any infringement suit, a patent holder, if unless he joined as plaintiff, will be added as defendant. But patentee added as defendant shall not be liable for any cost unless he enters in an appearance and takes part in the proceedings. Section 110. Right of licensee under Section 84 to take proceedings against infringement. Section 84 deals with compulsory license. Any person to whom license has been granted under Section 84, that is, compulsory license has been granted to any person, he may call upon the patentee for infringement suit, or to prevent any infringement of the patent, he may call upon the patentee to take any proceedings. Now, if the patentee refuses or neglects to do so within 2 months after being so called upon, then licensee may institute proceedings for infringement on his own name, as if he is the patent. And in that case, patentee will be defendant. But patentee added as defendant is not liable for any cost unless he enters in the appearance and takes part in the proceedings. Section 111. Restriction on power of court to grant damages or account of profit for infringement. Subsection 1. In a suit for infringement for patent, damage or account of profit shall not be granted against the defendant who proves that at the time of infringement he was not aware and had no reasonable ground for believing that the patent existed. That is, if the defendant proves that at the time of infringement he was not aware of the patent, or there is no reasonable ground for believing that the patent was existing, then in that case damage or account of profit shall not be granted against the defendant. Now, a person shall not be deemed to have been aware or to have had reasonable ground for believing that the patent exists by reason only of the application to an article of the word patent or patented or any word or words expressing or implying that a patent has been obtained for an article, unless number of patent accompanies the word or words in question. That is, only a word patent or patented is not sufficient to prove that it is a patent. There should be a patent number or application number, preferably a patent number if it is granted. Section 111, subsection 2. In any infringement suit for a patent, the court may refuse to grant any damage or account of profit in respect of infringement committed after failure of payment of renewal fee within prescribed time, or in case any extension has been requested if that period is also over. Subsection 3. Where an amendment has been done by way of disclaimer, correction, or explanation, no damage or account of profit shall be granted in any proceedings in respect of use of invention before the date of the decision allowing the amendment. That is, before there is any amendment, that won't be counted unless court is satisfied that the specification as originally published was framed in good faith and with reasonable skill and knowledge. Subsection 4. Nothing in this section shall affect the power of court to grant an injunction in any infringement suit for patent. Thank you all the viewers for watching the video. Hope you like it. Please give a like and please share and subscribe the channel Scientellectual. In all the videos, we are giving the informations which will be very helpful during preparation of Indian Patent Agent exam. Thank you again.